the Supreme Court.
Good morning again, folks. Thank you very much. Please be seated. Yep, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Watts, case number 23-AP302. Representing the appellant, Attorney Norman Watts, is Attorney Kaveh Shahi. Present with Attorney Shahi is Attorney Watts. Representing the appellee, Office of Disciplinary Counsel, is Attorney John Alexander.
Okay, thank you very much, counsel. Please come on up and, for the record, introduce yourself and identify your client, please.
Good morning, Mr. Chief Justice.
Good morning.
And good morning, Justices. This is Kaveh Shahi. I have the privilege of representing Norman Watts in this matter.
Thanks. Thanks very much.
I don't think there would be any doubt in anyone's mind if you have a prosecution that's conducted by a prosecutor who is your competitor in the legal field, your rival, and that prosecutor in the process of the prosecution is alleged to have violated some of the very rules that are being applied to Attorney Watts, and you're before a hearing panel that deals with those rules in a very different way, applies them in one manner to Attorney Watts, but yet applies them in an entirely different manner to the special prosecutor.
Attorney Shahi, are you suggesting that the selection of the Special Disciplinary Counsel was in violation of the existing PRB rules and or the PRB policy number 22?
That we don't know how the special prosecutor was selected, Your Honor. There's supposed to be guidelines, but the only criteria for the selection of the special prosecutor is that it's relegated to the chair of the board. And not only we don't know anything about the circumstances of how that selection was made, but also shortly before the hearing, as I pointed out in our brief, another member of the firm, Gravel and Shea, made an appearance as a special prosecutor.
Did you raise these concerns before the panel?
My client did at the time was pro se, and that's in the record. We made a reference to that portion.
Yes. Could you show us where that argument's preserved?
Yes, Your Honor. That was raised, and there was some vague reference about dealing with it later, but it was never dealt with. But I think, in addition to the issue of whether or not there was an actual conflict of interest, there is the question of due process here, which is a fundamental aspect of this presentation. The case law, this court's rulings have made it clear that there's nothing constitutionally offensive about combining the roles of investigation and prosecution. But when those roles are mixed, when those functions are intermixed, if you will, as they were here by the panel, with the decisions that were made relative to the allegations against the prosecutor, those decisions included essentially deciding not to investigate, deciding not to have bar counsel do a screening, and addressing the merits, essentially, and disposing, making dispositive rulings. Those are all beyond the roles that are anticipated by this court in having a system that functions with regard to the due process consideration.
But Mr. Shahi, the use of special counsel has been used in Vermont on a regular basis here and there. Before the assignment is made, should there be some type of evaluation as to what potential paths would be crossed between the special counsel and the respondent?
In terms of the conflict, Your Honor?
Yes, I mean, it's a small state with a small bar, and should that take place, and how does that actually occur?
Those are very good questions. We have no information. We have no knowledge. on how that happened. I do know that this started as being essentially treated by bar council as a fee dispute, and then it was elevated to this point. And we do know that regular counsel had a personal leave, and therefore special counsel was assigned. But we have no information as to how that evaluation was made. Was the law firm assigned? Was it an individual who was assigned? And what the process involved? It's a decision by the chair board. That's all we know.
So does that taint the entire process because of the potential for an economic gain to a private attorney who's going to act as special counsel?
I think, Your Honor, our argument looks at the collective set of events that happen here. I think that's one factor. Is a troublesome factor that we raised, but that's one factor. When you look at the way that the panel proceeded to deal with some of the same rules, essentially same applications. For example, the question of whether special counsel had made a false statement in her filing, which she had made a false statement that the motion for continuance was based on my having stated that there was too much discovery to review. It's a one-page motion. It's a very simple motion. You can read it. It doesn't say that. So that was a false statement. But the panel said, well, as soon as that was pointed out in our reply, special counsel corrected that. That was a span of, if you figured, about 13 days. The same, if you apply the same logic to what happened with Attorney Watts, on July 24, 2020, he wrote a letter saying that he had remitted the balance, retainer balance to GA, client GA. And then he realized that he had made a mistake, and he corrected that by August 6, 2020, 13 days later. So a correction by Attorney Watts is not only disregarded by the panel, but they say that he did this intentionally.
Well, but isn't that what the panel does? The panel listens to witnesses and listens to evidence and makes credibility determinations. So the board believed that that happened. So how is that a problem with the whole process?
Thank you, Arthur. It's a double standard. It's a double standard. You apply the rules.
How so? It's a credibility issue that the panel is making when hearing evidence. They decided that no, it wasn't correct, that Mr. Watts mistakenly didn't send the funds to his client. So how is that a process problem?
That's a process problem because it's an example of a situation where the rule is applied inconsistently. Now, the panel's conclusion really was based on the fact that Attorney Watts had received a reminder letter from special counsel some 10 days earlier. And therefore they said memory lapse was not a defense, was not an excuse. That's really a legal, in effect, a legal finding by them. Same can be said about special counsel. Special counsel produced a text message to the current bar counsel, disciplinary counsel, that included a text from GA during the hearing to her on an issue that he had testified about. That is whether or not he had any conversations with Attorney Watts about a motion. And on July 24, special counsel submitted proposed findings that repeated the statement that the testimony that GA gave.
If none of the irregularities that you're talking about today with disciplinary counsel and, you know, the board making that finding that you don't agree with, if none of that happened, is a year suspension appropriate? In other words, if the conduct is in fact found to have happened, what should the suspension or what should the sanction have been?
There are a number of alleged conducts involved here.
Mhm.
So we're looking at a due process issue with specifically talking about this misrepresentation that was allegedly made to special counsel. There are other issues about whether there was, with the withdrawal of counsel, whether there should be a disclosure of permission that's needed by court, whether that's part of the obligation of counsel. Generally speaking, any counsel wishes to withdraw, whether this court would find that it's an obligation to disclose that the withdrawal needs to be approved by the court. And there's a question of res judicata with the issue of commingling funds. So a number of issues. We would respectfully point out, and we've indicated in our brief, that under all these circumstances, an appropriate sanction would be 2 months suspension. That a year suspension at this point would essentially mean the end of Mr. Watts' career. And it's disproportionate to what essentially was a fee dispute that got escalated, regrettably, by the manner this thing was prosecuted, which raises a lot of red flags.
Counsel, could I direct your attention to the statement you just made about referencing the issue of the commingling of funds and res judicata? I'm intrigued by that argument because it seems to me that you are saying that if there's an audit conducted and it shows irregularities and there's discipline imposed, then you can't look at the attorney's account again in the future because it would be res judicata. Am I missing something here?
Your Honor, thank you for that question. And we're not arguing it as broadly as the question poses. We're saying that by the time that the PRB approved of an agreement that was stipulated in April of 2019, the representation ended by March of 2019. The audit period was previous year, October. That during that time frame, that's the time frame that we're looking at. So by the time that order is entered, res judicata is applicable up to that time. And if bar counsel, if disciplinary counsel at the time wanted to have an updated audit done, that was available to them. And we've cited a Ninth Circuit decision where, again, the same argument was used by analogy in a summary judgment situation where, or cut off of discovery. Res judicata applies to the date of judgment, not the date that, for example, discovery ends. And so one party can say, well, I didn't know before entry of judgment. So that's basically our argument, but certainly not an open-ended, and that's not the case here.
Okay.
Thank you.
Can I direct your attention also on a specific issue on count 4, count Roman numeral 4 regarding the withdrawal issues? As I read your brief, you say that the violations of Rule 1.4 and 8.4C should not be sustained because what really governs is Rule 1.16B5. Did you raise that issue below? And if so, how did you preserve it?
And again, Your Honor, this was my application for a short continuance so I can come up to speed was denied, and that's part of this appeal. So I did not represent Mr. Watts. He was pro se during the hearing. Whether it's the gray hair or whatnot, I don't have an answer for you, Honor. I have to look at the findings to see if that issue was raised.
And would you supplement it?
Yes, Your Honor.
Thank you.
But that is, I think, an important issue for the court. And we hope that is not addressed as a one of waiver, because we all need to know. This question of withdrawal is something commonly comes up, and we need to know if there's something more than you're required to do than 1.16, and whether you have to educate the client about what the court process would be for the withdrawal. Thank you. I don't know, my red light is on or not, but I will reserve the balance of my presentation. Thank you.
Thank you very much. We'll hear from counsel for the appellee, please. Come on up and identify yourself.
Good morning. My name is John Alexander, disciplinary counsel representing the Applee Office of Disciplinary Counsel.
Thank you.
We're here today to review a PRB panel's imposition of discipline for misconduct that is far more severe than a mere fee dispute. I think it's productive to review what got us here, and that the PRB hearing panel found that the respondent, Attorney Watts, committed 5 distinct violations of the rules of professional conduct, 2 of which the respondent does not even challenge on appeal. That is the unreasonable fees and expenses and the failure to return 2 client retainers in a prompt way. In addition, the hearing panel found that the respondent, 2 of these violations, RPC violations, involved dishonesty and deceit. It found that respondent committed dishonesty and deceit toward Special Disciplinary Counsel Spiro, as well as dishonesty and deceit toward his client, GA, in misrepresenting the circumstances by which he could cease work on his matter and withdraw from the representation.
You know, Mr. Henderson, I just want to make a point here. I went through the request to find that Special Disciplinary Counsel filed after the hearing. I don't know how you or your opposing counsel view it, but I was concerned that the word lying was used over and over again under circumstances that I'm afraid reflect what has become all too common in our popular culture. To accuse somebody of lying when they have misrepresented a fact, when they have forgotten a certain matter, in a way that belies a good faith effort to address real issues that are between 2 parties. And I don't have the luxury of making this point out on the street, but I do think it's important for us to keep in mind in a matter that comes before this court that involves the integrity of the system, which is what you are here to defend, what Mr. Shahi is here for, what my colleagues on the bench are here for. We're talking about the integrity of the system, and I don't like this sort of stuff in pleadings. I don't know why it was there. I don't know what happened between these 2 lawyers, Mr. Shahi and your predecessor. I don't know why it became like it was, but I can tell you this, I don't like it. I want to say that very plainly. I do not like it. It is beneath the system that you and I are honored to be involved in. And I was disturbed by it, I have to tell you, and I still am. So I wanted to tell you that. I understand these weren't your pleadings, and I'm not suggesting otherwise, but I do think that we need to be very clear between all of us as to what exactly it is that we're about in this system of justice that we're all here for. And it is to honor the system, to honor the basic integrity of each other. And I thought it was something less than that in what I read in these papers. I didn't like it.
Well, thank you, Your Honor, for that observation. And I do tend to see the word lie. It's a harsh judgment-laden term that certainly would get the attention of anyone on this court. I would note, just in sort of justifying SDC's nomenclature, that even the respondent concedes that he made a false statement to Special Disciplinary Counsel about the timing of the return of his client's retainer. What's really at issue is whether respondent made that admittedly false statement with knowledge of its falsity.
With intent. Well, this is the question, of course. But the intent is presumed, it seemed to me, in many of these instances where that was attributed. I just think it is bandied around in a way too free manner in a system where we take an oath to uphold this system. And that is not, in my judgment, honoring that commitment. That's what I'm trying to say.
Right. I do see, I have the luxury, the distance to observe that there was a considerable amount of rancor
Yep.
that evolved during the course of this disciplinary proceeding. And that's very unfortunate, although it's not unprecedented. There were some incendiary allegations made by both sides. There were allegations of racial or religious bias.
I
Fortunately,
saw
I'm not before this court.
Yeah,
But
I saw that.
I would be remiss.
For a moment then, Mr. Hernandez, since you raised it, and I know that in the respondent's brief, in a footnote, respondent's counsel indicated that you just raised the word racism was not an issue he wanted to pursue. There was a status conference that was not recorded, so we don't have a complete record. But there was a comment that was made, and no one refutes it because the order of the board does not indicate that the comment wasn't said. Rather, it's dropped in a footnote and simply says, you know, if there's racial prejudice or racism, I'll read exactly. I believe it's footnote 9. It refers to the rule, and it simply said, the footnote indicates, the provision does not prohibit a lawyer from discriminating against opposing counsel in a matter assuming there's no employment relationship between the lawyer and opposing counsel. We don't have that here. So it seems to say that, okay, perhaps there was racism here, but it's not as against the respondent. If that comment, he's not white, was made, then how does that not corrupt the whole process?
Well, I was not at the hearing. There is no recording of it. My understanding of that comment was simply, I suppose, an observation of the perceived ethnicity of some of the advocates. And obviously that observation really has no place in any proceeding.
Well, no place is, I mean, no place is giving a way too much, not enough issue. Somebody says that in a court against an opposing counsel, that's more than just a non-issue. That's a serious racial accusation that is way, way beyond anything that this state endures as part of our legal practice. It's shocking to me that something like that would occur in this legal system that we have in Vermont. And we pride ourselves on being able to work with each other and pride ourselves on our professionalism and not on making comments such as that on someone's race or ethnicity or both. And so it's more than just, if it happened, it happened. And I can't go with that.
Right. I as I said, I really don't have knowledge, and I don't think it's adequately reflected in the record what exactly was said. Maybe that comment, I think, was part of a broader discussion. I think it would be important to know the context of the statement. I do note that in the hearing panel decision, the hearing panel found that kind of bias, there was no evidence of that kind of bias occurring or affecting the proceeding at all.
Well, that was going to be my follow-up question. I agree with with my brother Justice and sister Justice's concerns here, but I'm looking for some record that this statement was made. And I've gone over the record carefully and I cannot find one. Do you know if there's one?
My understanding is that the alleged comment was made during the course of a status conference or a pre-hearing conference.
Which was not recorded.
Apparently it was not recorded and it was not really memorialized, or at least fully memorialized in a later order. All I can really represent to this court is I can look at the hearing panel decision and see their analysis of, yes, so the allegations of racial bias by SDC Spira, but we find there's really no basis to conclude that kind of bias was occurring in this case.
And would you agree it makes no difference whether or not it's to a individual on trial or a lawyer who's representing someone on trial? That type of behavior is not part of our culture.
I would agree. And that the footnote that Justice Wavell mentions, I think it's sort of an overly technical reading of that particular subpart of 8.4. I do tend to agree with the broader observation that comments on race or ethnicity of either a party or an advocate, except in very unusual situations, perhaps in a racial discrimination lawsuit, it really has no pertinence, and certainly had no pertinence there. And respondent and his counsel, to their great credit, put that footnote in their brief saying, that's not an issue in this appeal. It's not a basis for appeal or a claimed error. So a troubling and question that might merit further inquiries in a different proceeding, but for purposes of today, which is rather whether that infected the proceeding or prejudiced anyone's rights, I don't think even respondent makes that contention. So I do think the centerpiece of respondents' arguments on appeal is that the hearing panel declined the request of respondent or perhaps respondent's counsel to disqualify SDC Spiro prior to the merits hearing. And then when it declined to disqualify her, the later merits hearing was so infected by unfairness that a new merits hearing is warranted. And I think in addressing that argument, we need to address kind of one of the kind of threshold issues of appellate jurisprudence, which is, has the respondent furnished evidence or even made it a contention that he was actually prejudiced by SDC Spiro remaining as special disciplinary counsel, or by the hearing panel allowing her to try the case. And I don't think we find even the contention for respondent that her continued involvement in the case made any difference at all, that caused any prejudice at all to respondents' rights.
What about the appearance of Attorney Villegas signing a pleading? What's his role in this case, and where does that come from?
My understanding is that Attorney Villegas is an associate at what was then SDC Spiro's law firm, and he appeared in the case to provide assistance, essentially second chair assistance to SDC Spiro in trying the case. But it was SDC Spiro who was actually the primary advocate, examining witnesses, making openings and summations and so forth.
Was he appointed?
I do not see it reflected in the record that he received a formal appointment as a special disciplinary counsel or an assistant special disciplinary counsel, if there is such a thing. Again, this is an instance where there's simply a blank space in the record below that it does invite questions, although my position on that is, again, not even respondent claims that SDC or Mr. Villegas' assistance to SDC Spiro caused actual prejudice to him. He doesn't contend that having that additional attorney to help SDC Spiro somehow changed the outcome of the disciplinary proceeding. And so I think again, that threshold issue of harmless error could be relied upon to pass on that. So I see that I do have.
The sole issue on the disqualification was the fact that Gravel and Shea has an employment law practice, and Mr. Watt's primary practice was employment law.
Well, I think it's far more attenuated and speculative than that. Is my understanding, respondent claims that certain unnamed colleagues of SDC Spiro at her former law firm practice employment law as well, both on the plaintiff and defendant side. And so in that sense, they were rivals or adversaries to Mr. Watts. And the presumption is that SDC Spiro, who is not contended to be a rival or a competitor to respond in any way, in any case, somehow undertook to overly zealously prosecute him in order to suspend him from the practice of law, which would then presumably enable her private firm colleagues to get more clients, to prevail in more lawsuits, and that would reap greater fees, awards, and that would somehow make it back to SDC Spiro in terms of some kind of financial incentive. I do agree that there are a handful of cases saying that when a criminal prosecutor has a direct financial incentive to prosecute someone, that's impermissible. But that's not what's being contended here. The contention is that there are these very long chain of speculative, tenuous inferences that in some highly indirect way, SDC Spiro might have been motivated to prosecute respondent in a way that she otherwise would not have had her law firm colleagues not practice employment law. Again, this is an instance where there's been really no showing or even contention of actual prejudice from this purported conflict of interest. That, I think, addresses really the bulk of the respondents' arguments on appeal, which is that allowing SDC Spiro to remain on the case somehow was a due process violation. But before we even get to that, we have to address, was there any actual prejudice? And I don't think respondent even makes that contention. So I see that my time is up, and I thank the court.
Okay, thank you very much. How much time does the appellant have?
Appellant has 1 minute remaining.
Counsel.
Thank you, Your Honors. I just will conclude by indicating that this was an unfortunate situation with the delay in refund of retainers. It happened during the pandemic. The panel did find that the Watts, as a solo practitioner, was sloppy in the way he was managing his business at that time. And that's about it. There is everything beyond that, I would respectfully submit that has no merit here. And if this board is inclined to impose sanctions, it should be considerably less than the 1-year suspension. Thank you very much for your time.